Thank you very much. We're going to start our Ocean Nexus, Ocean Equity and Justice speaker series. I'm very grateful. We have 3 speakers and just wonderful lineup. I'm going to introduce first speaker, Professor Randall Abate. Randy has served as Assistant Dean for Environmental Law Studies at George Washington University Law since July 2022. He has 28 years of experience teaching, writing, managing programs, and mentoring students on domestic and international environmental law issues. From 2018 to 2020, Dean Abate serves as a professor in Department of Political Science and Sociology at Monmouth University, when I met him. And prior to the Monmouth, Professor Abate was a full-time faculty member at 6 U.S. law schools. And I'm not going to name all of it, if that's okay, but he has amazing experience. And he has 6 books and 30 journal articles, just plenty of the articles, and it's not just academic achievement he has, but his passion and really to understand what is environmental justice in legal, and as much as like a societal dimension is really what Randy actually works on. And, you know, I met Randy through one of the speaker series that you organized it, and somehow they decided to invite me, which was quite interesting choice. But then again, we had a really good conversation since then. Randy has been working with his student to produce a report on climate change and ocean governance, and we are going for another one for marine plastic pollution and some of the legal application from U.S. law. So I'm just hoping that our friendship and the collaboration will continue to really pursue ocean equity. And what I really wanted to hear from him is how does sort of environmental justice and ocean equity can we work together and can see the potential future to really secure people's dignity as an individuals. So I'll pass it to Randy and start talk.
Well, thank you so much for that kind introduction, Yoshi. It's wonderful to be here, and I echo the gratitude for our ongoing partnership on these issues, and it's mutually beneficial. It's rare that I have an opportunity to speak to non-legal audiences and work with non-lawyers, and I always appreciate it. I know I have so much to learn, and I like offering what little I can add to your knowledge base from the legal perspective. So it's really valuable to have these interdisciplinary conversations. And that prior position that I had at Monmouth University was really my first time stepping out of that law silo and working across disciplines. And I found it so valuable that now that I'm back in the law silo, so to speak, I'm at a major university campus that has graduate schools in all disciplines surrounding where I work at the law school. And it's just a great opportunity to continue that interdisciplinary collaboration, that has started, in my career, for the past, almost decade now, and really find it valuable. So I'm very, very excited to hear, your questions and comments about this presentation, and certainly, anything that doesn't make sense. I'm going to present it at a level that non-lawyers can appreciate, and because I certainly know if you were to try to teach me about science or economics, you would lose me at hello. So I'm going to build that understanding into what I share about. There's a lot of depth to the legal concepts here, and I'm going to just keep it at a level that's going to be more inclusive and relevant for a lot of the work that I know many of you are doing in the ocean governance space. So the topic is about a concept called standing in legal governance, which is, in an oversimplified way, how people get to go to court to bring a lawsuit. So this has been a huge issue in climate litigation, and my area of expertise is climate justice, which is an area of trying to have how we govern climate change work in a way that is going to protect marginalized, disproportionately burdened communities. And so this presentation is going to talk some about that, how these climate justice communities are not getting the protection they ought to because of this as one of many barriers for them securing protection. Just getting into court to be able to argue about what sort of protections they should enjoy under the law has been a big challenge. And then I'm going to also take a look at ways, first I'll tell you what this presentation is based on a chapter that I completed, and that's coming out this year. And it's a volume for those of you who are interested on many aspects of challenges like standing that relate to seeking climate justice in the courts. So it's a book that's actually prepared for the judiciary, because the judiciary has been very receptive to being trained on what they need to understand about climate change from legal and scientific and other perspectives, so that these kinds of cases can produce the just outcomes for the communities that are being adversely affected. So this book will be coming out later this year, and it's a compilation of chapters from scholars around the world looking at different aspects of climate litigation, many of which are from a justice perspective. So what I want to share with you is, as a starting point, this idea of climate justice communities, and I'll take you through how we've gotten there in terms of how the law recognized this concept. First, environmental justice, and then it transitioned into climate justice, and even most recently, ocean justice, most relevant for today's audience. And so I'll talk about different ways we have disproportionately burdened communities across those areas, and then connect that to the idea of these communities need to find a way for the law to protect their interests. And in many instances, they would be dead if they waited just for Congress to do something right to protect them. So they're taking matters into their own hands and bringing lawsuits, very strategic, creative lawsuits, to try to get the court system to protect their interests while they try to influence legislative bodies, of course, and that takes much longer and is much more difficult to secure. Just think about the U.S. at the federal level. We've known about climate change for 30 years or more, and it was just last year that Congress enacted something regulating climate change at the federal level in the U.S. So that just gives you a sense of how important litigation is to secure justice, because we certainly can't rely on Congress, which becomes seemingly more dysfunctional by the day, to provide justice for marginalized communities in the face of climate change and other equity concerns. So I'll take you through this, how standing is a barrier in trying to use the courts to get those just outcomes. And then I'll give you some case studies about how standing has been a barrier for these efforts in climate litigation. And then I'll try to give you, always try to end on a more hopeful note, which is hard to do in climate change. It's a very depressing subject. But climate justice is really kind of what keeps me going, because there's a lot of hope there in what's happening around the world, with these climate justice communities securing victories in the courts, is giving all of us some hope that these are very important mechanisms to do the best we can to protect the disproportionately burdened. So let's start with that idea of what we mean by disproportionately burdened. So if we go back, turn the clock back to the late 1980s, this is where the concept of environmental justice came into being. I was trained in the old system. I'm very old. So when I was in law school, environmental justice didn't even exist. It was environmental law. And really, environmental law was just about our federal environmental laws, our state environmental laws governing pollution. And that was it. And we were quite good at it, and we still are. We have very effective federal and state environmental laws that are essentially designed to protect humans from the adverse effects of the way we're polluting the world around us. So the Clean Air Act, the Clean Water Act, our hazardous waste laws, they're very much geared to recognize we had to do something about how we were destroying the planet with our impact on the environment, and have a system of regulating the pace at which we were doing that, the degree to which we were harming the environment. And so what happened in the late 80s was that we realized that those laws were working well, but it wasn't protecting everybody in the same way. So essentially, these laws worked in a way that we had what are known as environmentally undesirable land uses. So things like heavy industry, landfills, medical waste incinerators, all these things that were sources of harm to the environment. And studies were conducted that these environmentally undesirable facilities were almost always, especially in the southeastern United States, almost always located in Black communities. So essentially, even before we had environmental justice as a term, we had environmental racism, because that's essentially what it was. I mean, it was clear as the light of day that this is racism in its worst, most, kind of insidious form, that it was underscoring the fact that if you were economically and politically powerful, you didn't have to worry about these things being near where you lived, because you had the opportunity to ensure that they wouldn't be sited near you. And it was those lacking the political and economic power that were always the dumping grounds for our environmental impacts. And so that really kind of gave root to the environmental justice movement, that we had to be more equitable in how we were polluting the environment, where these burdens were being felt. And we didn't want those disproportionately burdened communities to have to shoulder those burdens more than the rest of society. And so that's an ongoing struggle. Environmental justice didn't stop once we had climate justice. It was really just the foundation of where we are now with climate justice. It's the same idea that you've got politically and economically disadvantaged communities that essentially are experiencing environmental problems, whether they be pollution or climate change impacts. They're experiencing those impacts first and worst is really kind of the way to think about it. And ultimately, they lack resources to protect themselves from those burdens. So if you think about indigenous communities or other low income or minority communities that are very much close to the resources that they rely on and feel those effects and are ultimately adversely affected by those impacts, much more so than the rest of society. And they're very ill-equipped to protect themselves from that. I mean, they certainly didn't cause a significant contribution to what we know as climate change, and yet those global climate change effects are affecting them first and worst. And so that's really the notion of the disproportionate burden that we see in all of these communities, whether they be environmental justice communities, climate justice, and now even ocean justice communities. It's the same idea. You are connected to, relying heavily on an environmental resource that's being polluted or affected in a way that's affecting your lifestyle, your livelihood. And the law needs to step in and protect you to the extent it can from shouldering those unfair burdens. So you look at different ways of how these communities can be burdened. I've talked about two of those anyway, and one relevant for today's discussion is small-scale fishing communities. Similarly, reliance on a resource that's really being adversely affected to an accelerated degree from sources like climate change and other kinds of pollution. And they are not going to be able to sustain their livelihood and their lifestyle without help from the law to ensure that they're getting the protections they need. It can't just be a social Darwinism kind of reality that the politics and economics of it will drive these communities out of their way of life where they live and suffer immeasurably without that intervention from the law. So another recent development in climate change is youth. I mean, we're seeing a very active youth movement now in climate justice, and not surprisingly, because those that are not yet of voting age, they are essentially sitting ducks for all the bad things that are going to happen from our governance systems. They don't even have the opportunity to vote the right people into office and the wrong people out. They're just inheriting a future that is so compromised already, and is only going to get worse until they have that opportunity to influence political decisions. So they're bringing a lot of lawsuits suing governments to do a better job. regulating climate change. So they have more of a sustainable future to look forward to. So the idea of standing then connects to this because all of these communities need to use our court system to vindicate their rights. And, that's a complex scenario because in many cases, the first step is arguing that they have a right that deserves to be protected. So that's one step that's quite daunting. But assuming they've got some kind of legal theory that can protect their rights, they have to get into court. And so the standing doctrine, and this is a quote from the late Justice Scalia on the U.S. Supreme Court, the standing doctrine asks, well, what's it to you? Why are you coming to court with this gripe? And that's, to most Americans may not realize, that's somewhat unique globally, that we have a very strict standing barrier to get into the U.S. court systems because it's rooted in our Constitution. Article 3, Section 2 of our Constitution says courts shall hear cases and controversies. And that language is what's given rise to this very strict requirement about who can get into court. And we'll be contrasting that with the idea of universal standing in other countries. If you've got something that you want to complain about, you can go into the courts and argue about it. You don't have to overcome that standing obstacle to get into court to argue about what matters to you in many other countries around the world. So it's not merely an annoyance. I mean, standing does provide a valuable role in our system of jurisprudence. It has this gatekeeping function. And the argument, which I found isn't always true, it's just one that's regularly used, is that standing is meant to protect the courts from being overwhelmed with too many lawsuits. And I'll mention later in the presentation that hasn't been true in environmental and social justice type litigation. And we've seen this from other countries that don't have standing barriers. They're not getting overwhelmed with these cases. It's a very much of a self-selecting process. You're not going to waste your time going to the court system unless you feel very strongly that you've been wronged. And so there's not going to be this floodgates problem. And there's also the time and the money involved in bringing these lawsuits. That's another self-selecting aspect of how cases ultimately reach the court. So the standing barrier is another layer to that complexity about getting into court and following a case to its conclusion. But the other piece that's been looming large in climate litigation, especially in the U.S., is the idea that the courts are supposed to play a limited role. They're more of like a referee in our three-branch system of governments. And so we have a lot of jurisprudence in our legal system that says courts should not make law. That's for Congress, and that's for the executive branch. Courts should be interpreting law. And so standing is another way of ensuring that balance of power across our three branches, that we don't want the judiciary to get too powerful. We don't want them to ultimately make law in deciding who wins a dispute, when that kind of concern should be in the political branches. So for instance, if you are a climate justice community and you're bringing a lawsuit to the courts, in many of these cases, the courts conclude that this outcome that you're seeking to get from us in the court is not redressable, that we don't have the capacity to give you a remedy. And much of that logic is connected to the fact that Congress is the one that should be addressing this issue, the executive branch. So when we think about climate change, it's an international problem. That's for the executive. And it's also a problem that relates to the governance of our atmosphere. And that's already addressed under our Clean Air Act, a federal environmental law. So many of the courts have said, yeah, you've got an interesting case here on the merits, but that's not for us. That's something for Congress or the executive to do something about. We aren't positioned to dispense justice for you. So it's important to remember how jurisdiction specific all of this is. The U.S. is the system that I grew up with and many of you grew up with, and it's just kind of taken for granted that, you just can't walk into court and complain about anything. The label for that is called a generalized grievance, and that's something courts do not allow in our system of governance. That it has to be a genuine conflict between two parties. You just can't go into court and say, I hate what the president is doing this week. That's something that belongs in Congress, not in the courts. So this idea of genuine case and controversy has boiled down to this 3-element test that we know as the standing test. And this is true, a similar kind of reality in other jurisdictions like the U.S. around the world, and I'll give some examples of those jurisdictions. But basically, standing in the environmental context, and this is somewhat anomalous in some ways, environmental standing is pretty broad, but getting into court for climate justice is still difficult, even though environmental standing has been interpreted broadly. So I'll give you some examples. Someone bringing a case has to be injured. Prior to the 1970s, when we had all these major federal environmental laws, injury used to be quite narrow. It used to be an economic injury, a physical injury, and that was pretty much the extent of what could get you into court. With the advent of our environmental statutes, injury was construed much more broadly, so that as an environmentalist, a member of an environmental group, you could assert injury on the basis of conservational interests, recreational interests, aesthetic interests. These were all valid forms of injury, which is much broader than mere physical or economic harm. So that's good for the environmental movement. Causation was always interpreted pretty liberally too. The idea is that there has to be a connection between the defendant's action or inaction and your alleged injury. And it doesn't have to be a direct cause and effect. It's just got to be some kind of a relationship between the two. And there's many cases in the environmental field that interpreted that causation link very liberally as well. So that wasn't really a barrier. Where we're seeing a lot of the barrier is with this redressability. And that relates to what I said earlier. And it's built into what's known as the political question doctrine, which tells us that message that I shared with you, that this is something that should not be before the courts. It belongs in the other branches of government. That's been a real barrier for environmental and climate cases. So there are a variety of approaches that are different from the U.S. I've mentioned the universal standing approach, and that's in many countries. And then there's kind of a middle ground in some other countries as well that makes the standing barrier less strict if it's a public interest type of matter. And surely climate change, climate justice litigation could easily be construed as a public interest kind of matter that could merit a lowering of the threshold of standing on those types of claims. And that's part of my argument. So basically, my argument is that climate change is unique. We haven't experienced this in the history of our governance around the world. It's an emergency. It's a global crisis. So it is utterly tragic if you've got disproportionately burdened communities that have a genuinely, potentially valid claim to bring to the courts, and they're not even being given their day in court, so to speak. They're being kicked out of the process at the courthouse door because they're not meeting standing. That to me is utterly tragic. So we have something that's urgent. We have something that is ultimately of legal merit in many ways that ought to be heard by the courts to develop the law about what duty we owe to these communities to better protect them from the harms they're facing, so that at least deserves to be heard by the court. They're not going to win just because they get into court, but they deserve to be heard and reach the merits of their claims. And it's important to realize that, again, given how slowly and ineffectively the legislative processes work around the world to protect vulnerable communities from climate change impacts, the courts are really the last resort. So it's like your last hope of getting any kind of legal protections, and you're being kicked out before you even get up to bat through the standing dismissal. And that's really very unfortunate. So where this has been an issue in climate change is unique. Again, it's a global problem. It's massively complex. It's being labeled as a super wicked problem for those of you who are familiar with that kind of terminology, because it's got so many layers to it. When I started teaching and writing about climate change, I still thought about it as an environmental problem. Back in the early 90s, when we had the Kyoto Protocol taking hold, we were thinking we were going to get ahead of this just by reducing greenhouse gas emissions. And now we know climate change governance is way more complex than that. It's not an environmental problem. It's a social problem. It's the ultimate social problem that humanity is facing. It's the ultimate calling out of capitalism and how capitalism has trashed the planet in a way that is unsustainable. And so many of the inequities that flow from climate change are really baked into how capitalism rewards economic development for its own sake, without considering harm to the environment, without considering harm to disproportionately burdened communities, and that has to change. So when we think about what it means to be injured by something so complex and super wicked as climate change, one of the initial barriers plaintiffs were facing is that, well, this is a global problem. And if you're trying to establish you've been injured, part of that effort is about you saying the harm is particular to you, that it's not something that everyone else or many other people suffer. There's something unique about how you're being harmed. And that's hard to do when you've got a global problem. And so there was language in the courts to the effect of injury to all might be injury to none. That if there's not something unique about your harm from climate change, that's again a generalized grievance that wouldn't be actionable. And then we've got these complex causal problems with climate change, although we're starting to overcome some of that with thanks to science and a new field called climate attribution science, which is getting much better at connecting specific actions or inactions to specific, more localized harms. So that's a very important development in bringing these suits, because otherwise it's very hard. And I'll give you an example of a U.S. case where causation was the grounds on which the case failed because of the complexity of connecting harm to actor. And then redressability, of course, we've talked about that, how the courts are reluctant to make law when this is something that's arguably better addressed by the political branches. So this image says a lot. This is a classic example of a disproportionately burdened community. Way up in the north slope of Alaska, right at the top where it starts to slope down, this native Alaskan community of 400 calls home on this narrow strip of land. And you might think, why would anyone choose to live on such a narrow strip of land? Well, they didn't choose to live on that narrow strip of land. It became more narrow because of coastal erosion from sea level rise over decades. And back in 2006, when this suit was brought, the U.S. Army Corps of Engineers determined in a risk assessment that this community had about 20 years to live on this narrow strip of land before they'd literally be in the water. And if you do the math, that's like 3 years from now. And they're still living there because they have not yet secured a legal remedy, which is tragic. And there are many, many other communities like Kivalina around the country and around the world that are facing similar do or die sort of circumstances about needing the law to protect them, and things are not moving fast enough or at all to get them out of harm's way. So with Kivalina, they didn't get any help from the federal government. That would have been the most logical way to get the money they needed. It's 400 native Alaskans, and they needed $400 million to relocate their community of 400, 10 miles inland to get to a place of safety. They clearly didn't have that money. The federal government was unwilling to offer it. The state of Alaska, governed by Sarah Palin at the time, surely was unwilling to offer that. And so what did they have left? Well, the lawsuit opportunity was left to them. They brought a very strategic, creative lawsuit against 24 of the leading oil and gas multinationals around the world. And you know the usual suspects, ExxonMobil, Chevron, Shell, Sunoco on that list, BP. And the argument was that these companies collectively contributed such a significant share of the global climate crisis that caused that sea level rise in northern Alaska that they should be the ones to pay that $400 million fee for their relocation. And what's really shocking, that as the studies and the evidence of the contribution of what are called carbon majors, these multinationals in the fossil fuel industry, there are fewer than 100 of these companies globally that are contributing 2/3 of global greenhouse gas emissions. As a lawyer, that makes you think we can fix this problem pretty fast. When it's not about, oh, it's just spread out over 200 countries. How are we ever going to fix this? Fewer than 100 companies are significantly responsible for this global crisis, and the law can do something about that pretty quickly. And we're starting to see the traction now, that the writing's on the wall, that they're not going to be able to do this much longer, at least in the U.S. So this case lost, and a big part of the reason why it lost was causation. Going back to that point about greenhouse gases globally causing that sea level rise, not surprisingly, the attorney for ExxonMobil stands up in court and says, there's no way to connect that sea level rise to my client's emissions. And that was true back in 2006. Can't argue with that. There was no scientific link to connect ExxonMobil's emissions to that sea level rise, so they were off the hook. But here we are almost 20 years later, and climate attribution science is closing that gap a bit more, so they're not going to be able to make that argument much longer, thankfully, because of the science advancements. But back then, it held up, and that Native Alaskan community couldn't even get into court to argue their claim. They were dismissed on standing grounds. So we're seeing this in other countries that have similar legal systems to the U.S. New Zealand, as one example, their special damage rule is very similar to that proposition in U.S. about injury. It has to be unique and special to you, and that's preventing otherwise meritorious climate change cases from going forward in the court system in New Zealand. The Philippines has been really ahead of the curve. They've been really good about kind of groundbreaking environmental jurisprudence to protect vulnerable communities, especially youth plaintiffs in that country. So there was this major case in 1993 that was brought by children, an environmental lawyer managing a group of youth plaintiffs that sued on behalf not only of those children, but on behalf of unborn youth as well, and arguing that there was a right to a clean environment that was being violated by deforestation in that country. But then a subsequent case just 6 years ago was dismissed on standing grounds because this was determined to be something that was not justiciable, not something the courts could address. The plaintiffs there were trying to argue that the roads in the Philippines are just overrun by cars, not unlike the U.S., but even worse. So the argument was that the government should implement a road sharing principle that would allow walkers and bikers to share the roads with the cars and not risk being killed anytime they set foot on the roads in the country. And that was considered something that the plaintiffs did not have standing to bring that case. That was something that was appropriate for the legislature, but not for the courts, which was surprising and disappointing given how forward thinking the Philippines has been and otherwise in environmental jurisprudence. So some things to think about in connecting all of this, again, back to the marine environment and to all these burdened communities. There's some lessons to consider, things that are happening now that might be good ways forward. So one is this idea of universal standing. Sounds like a panacea. It's much better than what we have in the U.S. It doesn't require you to meet those elements of standing. It just allows you into court and you're able to argue what's on your mind. But even that isn't perfect because there was a very significant climate justice case in the Netherlands that really kind of launched this recent wave of climate justice litigation, and that was the Urgenda case. And that was an entirely successful lawsuit. But the one place where they didn't succeed was that the plaintiffs there were trying to assert standing on behalf of future generations, those yet to be born in the Netherlands that also deserve protection. And the court didn't recognize that. Even in a standing that otherwise recognizes universal jurisdiction, it didn't permit the plaintiffs to speak on behalf of yet to be born citizens of the Netherlands. And that, to me, is not a perfect system. It needs to do better. That there needs to be a mechanism in the law that we can look out for those yet to be born. They're even more vulnerable than the current youth. And that's something that the law can do and has done in other countries. There are some countries that have what are called future generations commissions. They allow groups of living adults to speak on behalf of the interests of future generations, current ones and those yet to be born, and influence legislative proceedings, influence court proceedings with their input on behalf of future generations. So that's something clearly that even universal standing does not yet recognize and needs to. So I would also say that there are other people on the planet, or rather other entities on the planet, that deserve protection in the face of climate change because we're on this planet together. Non-human entities, whether we're talking about wildlife or natural resources, there's a massive movement afoot around the world to grant what's called legal personhood and rights of nature to protect non-human entities in the face of the climate crisis. And that sounds a bit radical to many people, but ultimately the law is not going to do nearly enough if it's focused exclusively on human interests. That's actually what got us into this crisis in the first place. Everything non-human was considered expendable, and now humans are in a major crisis because they weren't treating the rest of the planet, the non-humans, with the respect that they deserved and the legal protections that those non-humans deserved. We're in it together. It's a whole ecosystem balance model, and to get climate change governance right, we have to have legal protections for humans and non-humans. So universal standing doesn't yet provide that either. So then we've got all these approaches in strategic climate litigation that have been very successful, and that can also be applied in the marine context. So one of the main focus strategies of these climate justice litigation suits is it's arguing that the government needs to do more, and that's been very successful. So even governments that are doing something, unlike the U.S. until very recently, and it's still not much, even the cases where the government is responding to climate change, there have been successful lawsuits that say you weren't doing enough, and therefore you are responsible for failing what these plaintiffs deserve and are advocating for. And then you're seeing these rights-based theories as well, which are very creative. So in the U.S., one of the ones that I think is fascinating is that we have a due process clause in our U.S. federal constitution. And all it says is that life, liberty, and property shall not be deprived without due process of law. Very broad general language. That language was used to protect a woman's right to choose until recently. That language was used to protect same-sex marriage. These concepts were not on the mind of the framers in 1789, but the due process clause has been read very expansively because the Constitution is supposed to grow over time and reflect society's values. So the argument that youth plaintiffs made using the due process clause was that the court should recognize that we have a right to a stable climate system because all of our other rights mean nothing if the planet is trashed. So that was the argument that was used in the same-sex marriage case, that marriage is so fundamental to the enjoyment of other protected liberties we enjoy that it would be improper not to extend that liberty to same-sex couples if it's already recognized in traditional couples. And so the idea then is that logic could be extended a step further to say that if we don't have a right to a stable climate system, our whole system of protected liberties is essentially meaningless because they would be of no value without that fundamental right.
everyone. We're actually in our discussion today going to be pulling a little thread from what Randy was just discussing, which has to do with increasing efforts to collaborate with communities to manage marine resources, as well as the fact that there are different notions in the world about who has standing, who is a thing that needs to be protected, who can speak for what. And so those sort of ideas actually are what would have driven the work that Chris and I have been doing. And this Inclusive Ocean Data for Decision-Making project is a collaboration between the Information Schools Technology and Social Change Group and Ocean Nexus. And as innovation fellows with Ocean Nexus, Chris and I have been able to explore our interest in the relationship between information, technology, and community development, and to apply this to marine decision-making. So today we're going to briefly describe the Inclusive Ocean Data for Decision-Making project. We'll explain its conceptual foundations. We'll discuss a little bit the methodology, and we'll provide a brief overview of the guidebook. Both Chris and I, before I begin, I just want to say that both Chris and I are partly Western trained, partly non-Western trained, and we both come from middle income-ish backgrounds. And so this has sort of shaped the way we've engaged with the material and the way we present it. We've struggled with our own sense of identity. We've struggled with awareness of our own privilege in comparison to the organizations or the people, the communities that we want to serve or we hope to serve. We've struggled with the inclusiveness of our own practice and our authority to speak about topics like inclusion, indigenous knowledge, traditional knowledge. So we do not claim to be experts on this topic, but we do hope that our thoughts and reflections will be of some interest and use to anyone who's looking for new ways to genuinely engage with communities for marine protection. So the overall purpose of this project was to explore ways to foster data-based marine decision-making processes that are more inclusive of the realities and beliefs and practices of people in coastal communities. And we try to do this by developing a data literacy training resource for community organizations. The idea being that community organizations are better placed to work with their communities than we are. So we're just providing some tools that will hopefully support them. There were three motivations guiding us here. Our key concern was this observation that many communities do not fully participate in the entire process of decision-making, especially in generating the knowledge that is used to inform marine decision-making. And this is despite the fact that, as Randy alluded to, these are the people that suffer the most the negative impacts of climate change. And not just the negative impacts of climate change, but also the negative impacts of the efforts that are put in place to address climate change. And so we believe that actually communities can be fully involved in all stages, from the design of a research right to the point of decision making. When we talk about community participation in decision making, oftentimes we're just thinking about the decision making point, and that's when you might engage with the communities. What we're saying is no. You need to include them even when you're trying to figure out what information you need to make that decision. We also observed that the existing resources to support data for decision making usually does not target small non-governmental organizations. They usually lack context, or they're not adaptable to different community environments. And they usually focus very narrowly on statistics or data analysis skills. And so we wanted to produce something that touches on the entire research process rather than just those specific skills. And then we also observed that scientists oftentimes don't think of traditional knowledge as science or indigenous knowledge as science. And our argument is that these forms of knowledge are valid forms, scientific forms. So we should say indigenous science, not indigenous knowledge, for example. And so we're hoping that the work we do will encourage scientists and policymakers to be more receptive to these different ways of knowing. These this premise, led us to identify some barriers to community participation. And those are that, one, there's this lack of the actual resources that could support communities to do their own decision-making based on data. We also noticed this narrow framing of community participation, which usually involves communities maybe as labor rather than as thought partners. So with the data collection stage, you might consult or use community members as field workers. When the results are produced, you check with the community to see whether it aligns with how they see their world. And we're saying that it should be more than that. We also feel that one of the barriers is that it's difficult for scientists and for community members to engage from each other's perspectives. So most of the time, communities have to learn how to speak the language of scientists or of Western science, but you rarely find it in the opposite direction, where Western scientists or scientists in general feel the need to learn indigenous ways of generating knowledge. And so this acts as a barrier. And then communities may be disinterested in participating, maybe because of past experiences that made them distrustful of researchers, or actually distrustful of their leaders, and therefore distrustful of the process. Conceptually, we grounded this work in the idea of ocean equity, which underlines most of the Ocean Nexus's work. But we also drew on the idea of knowledge democracy, which recognizes all forms of knowledge and recognizes that all knowledge is relational. It recognizes that there's a vast body of often marginalized knowledge systems that are valid, equally valid ways of seeing the world. And it also, and this was really important for us, proposes that knowledge has to be transformed into action for it to be useful to society. So that was one of the most important drivers for us to develop this resource, because we wanted to translate academic knowledge into something that communities can use. We also use the Marginalized Voices framework to help us to identify voices that are people, communities, groups that may be missing from decision-making processes. So it's easy to know who is included, but it's not necessarily easy to know who is excluded, because invisibility is not obvious. So this framework provides a way to consciously think about who might be missing from the process. So we have unknown voices that are people that are invisible from mainstream society, which would be people like modern day slaves, undocumented migrants. Silent voices are those that lack the ability to vocalize their reality. So it might be people with certain types of handicaps or people, homeless people, for example. There may be muted voices, which are socially devalued or discredited, like sex workers. In some communities, it might be women. In some communities, it might be youth. We have unheard voices. These are just people that are difficult or costly to reach in data collection efforts because they might live in remote areas. And then we have ignored voices. And these are people that are marginalized during the data analysis stage. So the example would be indicators that are rolled into an other category or outliers. We're basically ignoring those voices. So ocean data for decision-making then is essentially a process of creating and using data in a way that recognizes and incorporates the realities of different types of people and I'll say things. It also aims to leverage as much as possible local knowledge and local epistemologies and to achieve the highest possible degree of community engagement, recognizing that there may be these existing barriers to community engagement and also very valid reasons that communities may not be able to participate, say because they don't have time or they're busy trying to make a livelihood. So we need to take all those things into consideration. And in the long term, we envision that this would lead to communities having a stronger voice and being more comprehensively involved in all stages of knowledge generation for marine decision making, and not only with respect to being able to gather their own data and pursue their own knowledge agendas, but also being able to communicate those agendas to policymakers and to the government. Now, this is not to say that scientists' expertise is irrelevant. I think scientists are important, they have the expertise, but we do want to find out or explore the extent to which we could be more inclusive in the research process while recognizing and leveraging the existing expertise of scientists. I hinted at this before. We're making a lot of assumptions when we talk about these ideas. One, we're assuming that with these basic competencies in research, design, data analysis, and so forth, communities will be able to participate more equitably in the decision-making process. We're also assuming that that participation will lead to better quality data. We are assuming that they will be willing and able to participate in the process. And we're assuming that different communities will have different skill needs, as well as different approaches to how they are taught and how they learn. So that has to be incorporated into the process. And very significantly, we are assuming that it is possible to integrate Western and indigenous traditional forms of knowledge. And so to provide the meat for our guidebook, we did some field work. First of all, in Hawaii, we did mostly conceptual work, talking to scholars and local community organizations to learn a little bit about this interaction of Western and indigenous knowledge, and to sort of test the ground to see whether this idea we had about a resource was even worth pursuing. In Japan, we explored with a professor there the oyster farmers' knowledge about ocean acidification and how to address it. And then in Ghana, we worked with a local organization there to explore community responses to marine protection efforts in the wake of a beaching event. And just very quickly to give an example of how we try to practice what we were preaching, is that for the project in Ghana, the local partner drove the entire research process. And we just gave them 2 parameters. We wanted it to be something to do with marine protection We wanted it to be something to do with, we wanted there to be a gender angle, if possible. Those were the only two things we told them, and they came up with their own research idea, did the field work, did the data analysis and interpretation. So I'm going to hand over to Chris now, and he's going to give us an overview of the resource itself. Just switch places.
Sure. Thank you. And hello, everybody. So now let's get into the actual resource itself. As we were designing and working, there was a couple of, well, there's several big buckets, but two of the big ones was, or what is the content that's actually going to go into it? And then what is the process by which we're going to be designing this and which people are going to be using it. So the content itself, we went back and forth and ended up on something that was modular. As Araba mentioned, we tried to assess our own biases given the education systems we came from, and tried not to assume how would any individual group go about a decision-making process in the first place. So we all are trained in certain ways to start with the question, and however we define the question of the problem and create methods or hypotheses, and then the methods, and then go about and do it, and we go through this way, but not everybody necessarily does it in that way. And so we want to create something that allowed for, to the extent possible, steps being in different orders than the ways we might look at it. I mean, even if we look at this presentation, it's really geared for this Western trained audience, where what was our question or our issue? Let's talk about the conceptual frameworks and who inspired it, and then we get into the thing, and then of course at the end of it, we're going to have what are the next steps. We all know what that formula is going to be, but not everybody works that way in decision-making processes around the world. So how do we create structures and create a tool that can be adaptable as much as possible? We weren't perfect in this, but we did our best, and we're looking forward to insight on how that can be done. We also worked to create case studies that were marine related and try to make this guidebook rooted in some of the communities that we work with. And so the artwork throughout this symbol here at the bottom, but also is a Ghanaian Adinkra symbol, which Araba, I'm sure, can give you tons of input on afterwards. It's all really interesting, and the work that you see throughout that's more painting or I guess everything is visual, but painting or graphic art. Those are done by a phenomenal artist in Hawaii named by Solomon Enos, who lent his art to this resource to represent some of these ideas and concepts we're doing in Hawaii. And then importantly, throughout the content, it's not just here are the skills, because we didn't want to assume what people's skill levels or competencies are. Some of it might be refreshers for some folks, some of it may be helping to build things that they haven't discussed. But really what we thought was important is, how do you connect every single aspect of this, everything that we're talking about, to inclusion? So it's not just what is methods, what does evaluation look like, but what does inclusive evaluation look like? What are examples and ways to put this together so that communities can think about what does that mean for them? There's this assumption that I think we need to be clear that we're not just talking about policymakers or Western trained scientists not including communities in these processes. We recognize too that communities themselves may not always be inclusive in the work that they do internally. And so how can these processes also help them to reflect on their own methods, their own ways of going about their work, so that they can also assess who is not in these activities and processes and what they do, so that they can build out their own inclusion as well as push to try to be included externally. And then looking at the process for how do we design, thinking about the different priorities for the training and how pedagogically do we assume that individuals would implement this within their groups, trying to have ways that have as much structure as possible, but also allow for flexibility and customization. So this is the guidebook. There's 12 sections, which again are modular, and you can dig into them, but it goes through, I think, linearly what many of us have experienced in decision-making, research, evaluation type processes. And here's some slides to just show examples of what this looks like. In this screenshot, there's a couple of pages from one of the chapters. Every single chapter begins with a quote or two from some scholar or local individual who has some really important thoughts, putting this into their own words. We tried to consistently have the purposes of each section and build in values, and you can see there's different kinds of artwork so that it has a similar feel, but also has the same kind of, so people know how to use it, and each thing can stand alone if it needs to. You can see in this one, I think what's important is this section on the right. It's kind of small, but being inclusive in choosing data and indicators. So each chapter has its own very clear-cut section about what does inclusion mean in the context of what we're talking about here. And then in this one, in gray at the top, we have a case study. So there's case studies throughout. And then there's also some worksheets and toolkits that people can use at the end. One thing, if you folks are interested in downloading this right now, that was available as a PDF in the very short term. We're finalizing an accessible PDF version, but also tools that can be used so people can create their own case studies. And so when they use it in their own communities, they can put in their own examples and do things that way. They can have accessible versions or editable versions of the worksheets and also the tool, the whole resource itself. So if they want to replace words, phrases, or ideas with things that are more locally relevant for them, they have the ability to do so. We had a long journey. We don't need to get into all of it, but we literally were in Hawaii in March of 2020, whatever fateful year that was, and about to start field work when we started realizing that, oh, the airports may close and we may not be able to get back home because there's this thing called COVID. Although I guess we didn't call it COVID at the time. There was something more racist than that. So we ended up, unfortunately, having to scrap a lot of our field work, much to our chagrin, also recognizing that these wonderful community groups that said they want to work with us and still said, oh, we know there's COVID, but we still want to work with you. We just kind of decided, well, we know there's a lot going on, and despite their generosity, we're going to take a step back and let them address this serious health incident. And so we ended up working much more insularly and less participatorily than all of this purports to say other people should do, but that was the reality. And so actually we have a bit of a flip model. So we're now hoping that the release of this and next steps will engage more communities to be able to see what we've done. But one of the positives was a lot of community members that we worked with initially got it and wanted to participate. So what's next is we have some pieces of this being released now. In the coming weeks, the more editable versions will be available. And we are really looking for input support from good people like you and you online. This is a painting by Solomon Enos of the Maka'inana. It's the term in Hawaii for people, the land, commoners, more to speak, just the natural people. And so it's representing the subservient nature that we all should have, whatever faith, what type of leader or in the work that we have. We're not forgetting that our service doesn't end by putting this out and onto the next project, but how can we continue to hear those voices and hear reflection to make ourselves better, but also to support this to evolve and grow in ways that continue to support communities in different ways. Thank you, everybody.
Thank you very much. We're going to go up. We can take one question. Well,
yeah, thanks so much. It's really interesting. I'd love to get more about the case studies and how, what you developed is being applied. You mentioned the thing about the internal conflict. That's the tool is helping reflect on their environment. I was wondering if there's a conflict between different stages, so that the decision you make in one stage of the process kind of restricts or limit your capacity in other stages. Did you find that, or is that this thing that's going to be kind of an issue that's going to come up as we increase the number of case studies in application?
Yes, well, because we didn't do the extent of field work we wanted to do, I can't say that we necessarily observed that, but in the cases that we read about, as well as in our reflection on the topic, I think that's the very reason why you want to try and include or be as inclusive as possible from the beginning. And at every stage, we're not saying that everybody has to be included in everything. The more important thing is to be aware of who you're leaving out and who you're keeping in, and have your rationale for doing that. And that should be a rationale that has been agreed. So you may be doing data analysis and people don't have the skill to do that particular type of data analysis in the community. It would be the more educated ones or the scientists who would be able to do this. At the point when you were doing your data collection, if you had been inclusive enough, you would have thought about what sort of skills we need to analyze this data. And then you decide, okay, we need XYZ skills. Do we have any alternatives? That will be more inclusive, or is this the way we have to go? And if this is the best method to do what we want to do, then we acknowledge that only certain people will be able to participate in the process. And we all agree that this is what we're going to do, and we understand, and we will make sure that we translate and explain this so that everybody understands. Those are the types of thought processes that we're trying to encourage people to go through. Just think about it, know why you're doing what you're doing, and make sure that there's a general agreement that a process can't be 100% inclusive, but there should be reasons for who is included and who is not included.
Thank you very much. We don't have much time left, but I just want to have even the 10 minutes of the discussion with three of you, if that's all possible. And it could be one of those traditions of the Nexus that we're going to have a very hard, heavy conversation potentially. So really to just point it out. So my question, so I'm going to start with Araba and Chris, right? To you guys is, like, do you see any chance that what you created, P4D, would potentially actually help the community to fight against the climate change or any of the injustice over there, but would it more towards like really to just understand what the community needs? I mean, do you actually see any potential for your product will be directly or potentially indirectly useful for something like what the land is doing? And I'm going to ask the same thing to Ryan. So you guys can have a conversation about right.
Let's change the world. That's it's going to go very quickly. I've already spoken quite a bit. Okay, I think it might. I cannot say that it will. And it will only be able to have this effect if people read it and try to use it from with an open mind and with a willingness to actually do or practice or try out the ideas. One of the most difficult things is going to be seeding control. And that's something that we dealt with as we said this. If a community organization feels that they know what is right for the community, they're not going to be able to just sit back and tell the community what you want to do. Let's discuss, and whatever you want to do, we'll do it. If you were able to read the cartoon we showed up there, the people in the community have said they want one thing, but the leaders were in another room saying, yeah, we know they want this, but I want this other thing instead because my uncle, is a contractor in that area. So as long as people are not coming in good faith to the process, then this is really not going to go anywhere. That's the first step, but we hope that there are at least enough people out there that are willing to at least take that step and try. And that's what we're going to be trying to do in our next phase, is to try and connect with communities and test it and see. We're saying that the things we've been doing in the past are not working, but we still have this severe social inequality. So we need to do something different. Here's something different. Let's try it and see whether it works or not.
Thank you so much. So now back to Randy. You had Araba's talk, and surely there's a missing or gaps in litigation in terms of information, getting a community voices, understanding what they want, and bringing it up to the level where they could just take some of the people or some of the companies in the court. What do you think that we actually need as a resource? You know, what's the missing link between what Araba and Chris potentially doing and what you're doing, and how can we fill that?
Yeah, you put your finger on it. It's about information, and you know, so a lot of my presentation focused on what are known as, you know, substantive legal protection. So recognizing a community has a right to something that they're not getting, and the law confers that right. But another big component that I didn't address about what it means for human rights to be respected in the context of climate justice are procedural protections, and one of the quintessential procedural protections is access to information and dissemination of information, because that's really what builds the foundation for the law to protect your interests. And in many ways, we are living in this world where the law is in that other house, and the information we need is happening down there, and it's not getting to that house. And this project, which is wonderful and fascinating, is a way to build that bridge so that the information from those adversely affected reaches those that are in the position to do something about it. And so I think there's a lot that way that even, and I think you mentioned the idea about even the efforts to address the problem burden the affected communities. And so I'm living proof of that myself, and I like to admit that as an illustration. So I'm involved in climate displacement issues and climate refugees, and how the law can do a better job protecting those that are in danger of being displaced. And I remember when I visited Vanuatu in the South Pacific, my assumption was that, well, of course, these people who are in danger of being inundated want to have a place to go when that day comes. And what I was in the other house, basically, with that assumption, because when I talked to the people, their plan was quite different. They did not plan to move anywhere, not even to another island in the South Pacific. They are essentially going down with the ship. This is home, nothing else is. And so the best thing we can do from a climate change displacement legal framework is do everything possible to keep them in place, not figure out where they're going to go next, because that's not what they want. They need to be asked what they want, and then the law can better respond to the extent possible to fulfill what they need. But you're never going to know that without getting it.
Thank you so much. I mean, that leads to another quite heavy conversation, because usually when I talk to the people, let's go for the rights of the nature. If the community, and also community interest, if community decide to really, in the short term, thrive with economic benefit, and then so they can actually accumulate enough resources to just move it somewhere or protect themselves and doing something, and it might not be super conservation friendly. Or if the right to nature and conservation of the animal rights and all sorts will actually potentially in the longer term better for the community, but yet doesn't really necessarily fulfill the community needs immediately. They got to think about tomorrow's livelihood. When this happens, right, what can we do? Any comments on that? Because I usually get this question, and so whoever can take this question to answer, that'd be great.
And I think one of the things in the very beginning of the guidebook we put together, we decided was to talk about values and priorities within the community, and to make sure that that's an inclusive conversation, because within any community there's different groups of it, but to put them out there and to describe it, right? What you just said is a value-laden piece, right? And maybe some people just don't value the environment in certain ways as they value the health of their community, and they may just define health in certain ways. And not to say that we expect this to be used to justify environmental destruction, but to still put out there and help people to map that out and to describe these are our values and why, and this is the community, you know, the drive that we're moving towards. and it impacts every single step along the process,
Mm.
right? And every piece of this and how we describe the methods, how you can describe what data and information is, right? Data is, in this case, doesn't necessarily mean it's just numbers, right? It's just information. It's a way of saying information. And so how can values drive this decision making? And then how can, if somebody is able to put that out there and not just say, this is our decision, but say, and this is why, and put in that context, then it can get to that human level, right? And that's kind of one of the differences between some maybe more this old school Western type of science where it's just about numbers and counting and chemistry or fish counts, right? Versus a lot of traditional ways which have that, plus understanding the cultural components, the human components, the value components. And when we add the human to it, then we can have conversations about this is that thing that we're viewing and that we're measuring. And this is how we're seeing it through our lenses of our communities. And then we can talk about that and connect as people, and maybe it can help to bridge some of the political stuff, which often we forget that we're people behind all these values that we are.
Randy, can we take this conversation to the court?
Yes, I think in many ways, this is the important first step in making a legal argument. I think, a lot of the challenge in addressing a problem like climate change is that in the US anyway, it put us into two camps. Either you believe it's real and you want to do something about it, or we can just ignore it and all that really matters is economic productivity. And then of course the reality is somewhere in between those two extremes. So a lot of it is that the information that's gathered is the best tool for educating the public. And so I've really gotten much more immersed in the whole field of climate change communication, because it's something that everybody needs, wherever you are in society, about how this is a fundamentally social human rights kind of problem that we all have to confront, and that we all have to be aware of what the options are, and we have to be inclusive in hearing the different perspectives. And it's not just financial gain or environmental protection. It is about kind of retooling the way we do a lot of things, and the whole idea of the Green New Deal sort of recognizes that this is a social transformation that we all have to be a part of, wherever we are in that mix of players in the game, and we're just not listening to each other, and that's what's really getting us into more trouble, and ever hoping to get a solution that has some traction in addressing these problems. It's just not this black and white either or scenario.
Can I say just one thing? I think we may be surprised at what could happen, what could emerge if we would just listen to each other. Just having those conversations and really listening to each other. Who knows, may be able to figure out that compromise that both protects whatever values we have now, as well as protecting the future generations.
Thank you. Very different way of either inviting them to listen to each other, or somehow taking them to listen to each other. Very different way, but thank you very much for today's conversation and presentation, and we learned a lot from you. And thanks to everyone online. We'll catch up soon. Okay, great. Thank you.